Hello, everyone. This is Attorney Louis Liu. I'm a New York corporate lawyer and litigator. Today, I will explain to you what to do if you receive an attorney demand letter. You open a mail and there's a letter from a law firm. It says you have breached a contract or infringed upon somebody else's right, and that unless you do this or that, they will sue you. So what do you do now? Okay, I see two kind of different reactions. Some people will panic and write a long reply that night and explaining, apologizing, arguing the merits of the dispute from his perspective and put that in writing, several things that you never actually want to admit. Other people laugh it off and quietly delete all the evidences, being it email or text message or any other kind of records, uh, because they think those kind of things will haunt them if the other side does commence a lawsuit. Both are wrong, and the second is even dangerous. So let me cover a few key points today on attorney demand letters. First, what the letter is and what it is not. A demand letter or a cease and desist letter is in substance just a letter from a law firm. A law firm is not a judge, it's not a court. It has no power to issue you a subpoena, an injunction, or a judgment. With very limited exceptions, which I'll cover today, you have no obligation to reply or to comply with whatever they demand you to do in the demand letter. So the deadline there chosen by the lawyer who wrote it is not fixed by law or set by a court. It just, artificially imposed upon you psychologically to, pressure you. But you cannot put the letter aside either as if nothing had happened. Because the moment you read it, something magically has happened. Okay. And what is that? So here comes my second point. Okay. That's the magic, the litigation hold in that well-drafted attorney letter, if it is well-drafted. Under American law, the moment a party reasonably anticipates litigation, the duty for that party to preserve evidence arises immediately without any court order. Service of a demand letter from your opponent upon you is a classic trigger of that obligation of you to preserve evidence. The duty attaches when you finish reading it, before you hire anyone or a lawyer, regardless how you think of the substance of the claim outlined in attorney's demand letter. So you should stop routine destruction of your organization's email message or other records. You should suspend all these automatic email deletion that has been programmed by your IT department. And you should secure all these relevant contracts, books, records, invoices, whatnot that may be evidence in this potential lawsuit. And you should instruct your IT and other relevant people to do this and comply with this demand. If you delete anyway, the consequence can lead to what we lawyers call spoliation. Under Federal Rule of Civil Procedure 37E, if the loss of evidence prejudices the other side, the court may order measures to cure that prejudice. It's all legalese. What does that mean in plain English? It means that if the court finds that you acted with intent to purposely delete relevant evidences, which may make it more difficult for the other side to build a case against you, it may instruct the jury to assume the evidence that had been deleted by you was unfavorable to you, and it will prevent you from offering any proof on the issue to defend yourself. And it may even order you to pay the other side a legal fee for trying to making you produce this evidence. Worse, the judge may just enter a judgment directly without going through the trial against you for essentially destroying your evidence that are under your possession. When you have been told that you may be sued, you shall not touch this evidence. Okay, so a case that could have been won may be lost, not on the facts, not on the law, but on the act of your deleting the relevant evidence after you have been told not to do it. Okay, my third point is that do not try to reply to the alternate letter on your own. Even if you feel compelled to counter what the writer had put down in his letter, that's just human tendency to defend himself or his organization. But try to resist that kind of impulse, because everything you write down can be used against you. Any explanation, apology, or concession may be later treated as your admission of your liability. And certain facts you wrote down, right, will be used against you if later on you try to advance a different, version of facts in order to, support another legal theory that you did not know of, right? We're not trying to teach you to lie, but also the thing that you put down may be factually inaccurate, right? So, for example, a client may write a sincere line to respond to an alternate demand letter saying, I honestly did not realize the contract was still in force, right? He thought he was trying to clear things up, but the opposing counsel saw three concessions in one sentence already. A, the contract existed, okay? He can no longer argue there was no contract. B, the potential defendant knew of the contract. I honestly did not realize contract was in force. Was still in force, but it was in force at some point of time then. And then third, that his thought process, right? He saw the contract was no longer in force, right? And those kind of factual confession or admission may backfire. So you need resist this temptation to respond and talk to your lawyer and figure out the following things, the four things that you need to do. Okay, how to do it. A, as I just explained, you need to preserve all the relevant evidence. And then second, B, you need to investigate the facts. You need to understand what actually happened. There may be misunderstanding about facts from the other side or on your own part, right? And then you may need to, third thing, you may need to notify your insurance carrier. There are general liability and D&O and professional liability or homeowner liability insurance coverage that will require you to notify your insurance carrier in order for the potential damage to be covered, okay, by the policy. So, and then you need to sit down with your lawyer, go over the facts, and have your lawyer apply the law to the facts and come up with sensible defenses and counterclaims and figure out venue and statute of limitations, issues like that before your lawyer sits down to produce a draft to respond to that demand letter. If you assess the totality of circumstance that the best course of action is to respond to that alternate demand letter. You need a strategy based upon thorough investigation of the facts, thorough understanding of the law, and applying the law to the facts, and taking into account each other's position, including, the statute of limitation and other side potential budget and resolve to fight you, okay, all into account to produce an intelligent response to an alternate demand letter. So conversely, those are the following 4 things that you should not do. I'm repeating myself now. Do not delete or organize evidences, okay? Tampering with evidence. Do not reply the alternate demand letter on your own. Do not go around your counsel to approach the opposing counsel, okay? Do not ignore the demand letter. Analyze it, understand it, okay? Before you write a full letter of indignation in response. Okay, this is today's topic. This video does not constitute any legal advice to anybody, and it does contain some element of legal advertisement. If you need legal advice, please reach out to us at www.ambizlaw.com or call me at 917-698-3258. Thank you.